All rise and give your attention. The Honorable Justices of the Montana Supreme Court.
Please be seated. Good morning, everyone, and welcome. Before we begin, just a reminder to everyone, please check your cell phones. Make sure they are silenced. We have a little bit of a different lineup today, so I'll start by introducing everyone. I'm Beth Baker, and I will be acting Chief Justice today in place of Chief Justice McGrath, who has recused himself. And we have 3 members of the court who are appearing remotely. And since we can't see you, I'm going to just call on them to make sure you can hear us, judges, and we can hear you. I'd like to begin with Judge Elizabeth Best, who's sitting by designation in place of the Chief Justice. Can you hear us all right, Judge Best?
I can. Good morning.
Good morning. And then Justice Dirk Sandefur.
Good morning. Yes, I can.
All right. And Justice Ingrid Gustafson.
Yes, good morning. Sorry, I'm a little hoarse today.
All right. And then members of the court here are Justice Jim Rice, Justice Jim Shea, and Justice Larry King. So this is cause number DA 23-0272, the time set for oral argument in Planned Parenthood of Montana and others versus the state of Montana and the Attorney General. Are counsel ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
Mr. Lee?
May it please the court, Brett Mead representing the state of Montana. I'd like to reserve 10 minutes for rebuttal. This court should reverse the district court for 3 reasons. First, the district court incorrectly applied a strict scrutiny plus test to a claim under Article 2, Section 15. Second, the Consent Act satisfies Article 2, Section 15 because the law protects minors, promotes parent-child relationships, and contains a judicial bypass procedure that protects minors' access to abortion when parental involvement is inappropriate. Third, at a minimum, this court should remand for trial to resolve disputed facts because the district court incorrectly viewed the Consent and Notice Acts as interchangeable in their policy objectives. The Consent Act closes a known loophole that Planned Parenthood acknowledged exists in their due process challenge to the Notice Act. Montana Constitution, Montana law, and this court's precedents recognize the basic truth that children are different from adults and require protection. That can be found in the plain text of Article 2, Section 15, and it is foundational to much of this court's jurisprudence, looking at cases like Steelman, where we impose different sentences on minors because we find that minors, because of their brain development, are less culpable than adults for the same crime.
Excuse me, counsel. I don't understand what the outstanding factual issue here is here as you've described it. I don't see it. What is it?
To clarify, Your Honor, are you talking about the disputed facts that are pending below on the Notice Act?
Yes, you said that there was a genuine issue of material fact that should preclude summary judgment here. What is it?
As we stated in our briefing, Your Honor, there are remaining disputed facts as to the relative safety of carrying a pregnancy to term versus the safety of abortion as applied to the Notice Act. There are material disputes on the Notice Act as to the effect of parental involvement in improving outcomes for the minors. There are remaining.
Excuse me, counsel. The Notice Act, as I understand it, isn't before us today. Today is about the Consent Act. And the district court, as I understand it, has already denied summary judgment to Planned Parenthood on the Notice Act because of noted outstanding factual questions. So what are you talking about in regard to the Consent Act?
Yes, Your Honor, the district court denied summary judgment on the Notice Act. And the state's argument is that the district court committed a fundamental error by viewing the Consent Act and Notice Act interchangeable. That the district court's reasoning.
Counsel, you're not answering my question. I asked you, what is the outstanding issue of material fact that precludes summary judgment on the Consent Act?
Your Honor, it's the same class of facts that exist for trial on the Notice Act because the district court didn't resolve those disputes as applied to the Consent Act because it viewed as a matter of law that the Notice Act is a less restrictive means than the Consent Act. And that's an error of law. They aren't interchangeable in that way. And that was the state's argument that when we're talking about what the Consent Act does that's different than the Notice Act, it requires proof of parental identification and it requires proof of parental relationship before as an element of that consent. The district court said that that is necessarily more restrictive than the Notice Act, and so it fails strict scrutiny. But that's a question of law. The district court didn't resolve that class of disputed facts that remain for the Notice Act. It didn't resolve those as to the Consent Act because it viewed as a matter of law this issue of less restrictive means. But that's an incorrect legal test, Your Honor.
That's my point, and I'm going to quit badgering you about this because we're just going to disagree. But you keep saying it's an error of law, it's a matter of law, and you're talking about how to interpret facts that are undisputed here on this record, which is an issue of law, not fact, as I see it. So unless you can enlighten me on that, you can move on, and I'll leave you alone on this.
Well, Your Honor, we'll probably return to it later, but what for the state's position is that when we look to the facts on appeal, the state doesn't believe it's in dispute that the state forwarded valid protected interests towards minors, and the state doesn't that because those facts aren't in dispute, this court can reverse and grant summary judgment to the state. The state's argument in part 3 of our brief is that at worst, because there are that same set of facts for the Notice Act and Consent Act still in dispute, the worst this court can do is remand for a trial to resolve those acknowledged facts that are in dispute below on the Notice Act.
Well, counsel, if we are applying a strict scrutiny level of review, though, I mean, isn't it just, I mean, parental notification is less restrictive than parental consent, isn't it?
No, Your Honor. And so this gets to what the state has been arguing, that when you look to Planned Parenthood's briefing, one of their claims against the Notice Act is a due process challenge that says a constitutional flaw in that law is that they can be held liable for providing notice to someone who is not the parent. That argument acknowledges exactly what the Consent Act is closing. That the Consent Act is designed to require proof of who the parent is and proof of that relationship to close that due process loophole that Planned Parenthood's identified and is most apparent in the Ohio Roe case that we cite, where an adult abuser coerced the minor in that case to provide his contact information, not the parent's contact information, to the abortion provider for purposes of Ohio's Notice Act.
But they're not, I mean, then isn't the issue then is amending the Parental Notification Act, if we're talking about less restrictive means, importing that notice requirement to the Parental Notification Act rather than supplanting the Parental Notification Act with the Parental Consent Act.
Your Honor, the identification requirements that are in statute for the Consent Act, they are the two pieces of information and the only two pieces of information that can close that loophole. That it's proof of ID.
No, I get what you're saying there. I'm saying, can't you take those two considerations and amend the Parental Notification Act to include those provisions, those identification provisions. And that then that closes that loophole with the Parental Notification Act, and the Parental Notification Act remains the less restrictive means from a strict scrutiny standpoint.
I don't believe it's possible. I don't believe it's constitutionally required. That when we look to,
And I'm sorry, I don't mean to, but what is I'm saying, if this is a strict scrutiny analysis, and I know we're going to get into the interplay between Article 2, Section 10 and Article 2, Section 15, but if this is a strict scrutiny analysis, then it's not just, is there something else already in existence that would be a less restrictive and more narrowly tailored means? Under strict scrutiny, it's just, can there be a less restrictive means, a more narrowly tailored? So the parental notification, neither of these are carved in stone. They're all, and the legislature amends statutes all the time. So it's not necessarily that the Parental Notification Act would have to be supplanted by an entirely new act, so much as taking what you're referring to as this loophole and importing it into the Parental Notification Act.
Your Honor, I believe that leaves you effectively with the Consent Act. I don't think that there's much of a distinction between what the Consent Act does and what that would do on the Notice Act.
And you're talking, well, it would be notice. You're talking about, what I'm saying is, and maybe I'm not saying it very clearly, and I apologize if I'm not, but what I'm saying is your fundamental distinction between the two acts is the identification requirements for the parent or guardian in the Consent Act. I'm saying you import that requirement to the less restrictive Notice Act, and the fundamental difference then is one requires only notice to the parent who has been conclusively identified, and the other one would require the parental consent.
So Your Honor, the reason why I say I don't think there's much of a distinction is that in the subset of cases in which there would be a different outcome in whether the minor obtains an abortion between the Consent and Notice Act, the judicial bypass provision is what saves that. And so if the parents were in that hypothetical case to stand as an obstruction with this modified Notice Act or the Consent Act, the minor can still get a waiver.
No, and I'm sorry, I think I'm talking about modification of the Notice Act, not the Consent Act. And so doesn't that leave you with a less restrictive means while still closing the loophole that you're speaking of relative to the Notice Act?
So Your Honor, I don't think so, but I don't think there's a huge difference so long as the requirement for notarization and that proof is still there. I don't think that there's a large amount of difference. And that's one thing the district court objected to in its order, was that requiring notarized affidavits somehow imposed a burden. He did not cite to anything in the record on that. And so it's the state's position that when you combine those identification elements with the notarization, that's what we're getting to with trying to ensure parental involvement.
Council, maybe I could take off from there. The backdrop for the issues of application of strict scrutiny and the least restrictive means come from Armstrong in large part. The Armstrong line of cases, the district court relied on Armstrong extensively in its decision. The state's opening brief doesn't mention Armstrong, and I guess that makes this different from more recent abortion-related cases, because the state's not trying to defend the bill on the basis of a medically acknowledged bona fide health risk that it's seeking to protect, but rather under the protections of minors under Article 2, Section 15. So how does the state react to the district court's heavy reliance on Armstrong, that it has to overlap and from which we get a strict scrutiny review and the requirement for least restrictive means?
So three 3 points, Your Honor. First, as a first order matter, Article 2, Section 15 plainly allows the preclusion of a minor's fundamental rights if a law is designed to enhance their protections. And so that is consistent with decades of Montana law. It's consistent with the intent of the delegates as expressed by Delegate Monroe, that under Article 2, Section 15, a minor's rights can be infringed if the law is designed to protect them. And so in this case, the full Article 2, Section 10 right to privacy doesn't attach because the law is designed to protect them. In that protected interest, the state did forward health and safety risks related to minors. So it overlaps somewhat with Armstrong as one subset of the protected interest, that there are risks to minors who obtain an abortion, that they have both physical and psychological risk to that procedure. The psychological risk can manifest years later. Physical risk might manifest 48 to 96 hours later. And the reason why parental involvement is in the protected interest of the minor is, as we have in the record, the plaintiffs don't require follow-up care on a minor who obtains an abortion. And so the parental involvement provision is there to ensure that there is someone who is observing the minor for these symptoms when they manifest, either in the case of some physical symptoms like internal bleeding, that if that manifests 2 or 4 days later.
But the act doesn't require that, right? I mean, the act doesn't require the parent to monitor the child or do anything, right?
Your Honor, that's because parental involvement furthers the fundamental rights of parents to care and nurture their children. And it's
so the parent's right to fundamentally care for their child could be to deny them an abortion, but or even allow them an abortion and then just not pay any attention to them in the recovery phase.
Two responses to that, Your Honor. First is that when you look to our general minor medical consent statute, as a general matter, parents must consent to medical care for their children. Of course, nothing in that statute requires that they direct their child to care. That's dealt with through other family law. And second, encouraging the district court's opinion, I think, just got it fundamentally wrong. The state's not disputing that abortion is a serious procedure that needs to be treated delicately and with care. The state's position is there needs to be someone there to offer some support for the child. And
Could
as
I interrupt for just 1 minute? Just circling back to what Justice Sandifer asked you about when we started. You are saying that the state was entitled to summary judgment. So does that not mean you're arguing about a lot of factual issues here? And are you suggesting that there are no material factual issues as to the state's position?
That's correct, Your Honor. There's no dispute that the state is furthering a valid protected interest in the consent statute when it is aimed to improve the informed consent provisions of our abortion chapter laws. That there's no dispute that the state is furthering a valid protected interest when it is, as the U.S. Supreme Court identified in Matheson, encouraging parental involvement, because that parental involvement naturally gives abortion providers better access to a minor's medical history. And there's no dispute.
But you just told Justice Sandifer that there are material fact issues. So I'm confused about the state's position just on a foundational basis for this appeal.
I hope I can clarify it so that the state does not think that there are disputes with material facts as to the state's protected interest. What is in dispute below on the Notice Act are the facts surrounding Planned Parenthood's equal protection challenge.
But we're not deciding that, are we? that's the judge, the district court judge left that for trial.
Correct, Your Honor, but once this court applies the correct legal test, and that means correctly viewing that the Consent Act serves a slightly different policy objective than the Notice Act, then the district court has to confront those disputed facts as applied to the Consent Act. That class of, I believe it's 8 factual issues that remain in dispute below.
Counsel, let's talk about the correct standard here. Because you were just talking about Article 2, Section 15 as the constitutional nail, for lack of a better term, to hang the state's hat on, as far as trying to show a compelling interest in a narrowly tailored measure to protect children. But aside from the fact that you're glossing over the general rule of Article 2, Section 15, that minors have all of the full complement of fundamental rights that adults have under Article 2, you're jumping down into the exception under Article 2, Section 15, to show that there's a to get there. But logically, if that's where the focus of the case is, you've already then, although you don't want to say the words, you're already then conceding that the Consent Act substantially interferes with the exercise of the right to privacy of these young women. Is that not the case?
Your Honor, the state's not arguing that an act like the Consent Act would be appropriate for adults.
No, I'm asking you is if, do you agree or disagree that the Consent Act on its face substantially interferes with the exercise of the Armstrong autonomous decisional privacy right by minors?
The state disagrees that the full Armstrong right attaches in this case. And that's because, as Delegate Monroe stated, the intent of the preclusion clause was, and the state acknowledged in briefing, and we've acknowledged throughout the case, as a presumptive matter, Article 2, Section 15 puts minors and adults on equal footing for constitutional rights. The preclusion clause acts as an exception, and that's where the district court erred by not reading and not analyzing preclusion.
Thank you, but that's my point, is even to use your own words earlier in this argument, you told us a few minutes ago that the exception clause in Article 2, Section 15 allows the state, when for the proper reasons, to infringe upon the minor's right to decisional autonomy and privacy. And so when you make a statement like that, does that not effectively concede that there is an infringement here that is substantial, but then it's being justified, as you say, on this other end of the exception to Article 2, Section 15. But when you acknowledge expressly or implicitly or effectively that there is an infringement, but it's justified, that triggers strict scrutiny.
I agree with the first part of that statement, but not the last part. Strict scrutiny doesn't trigger to laws that protect minors. As an analogy,
It absolutely does, because putting the reasonable time, place, manner moniker on a state restriction doesn't just eliminate what triggers strict scrutiny as a matter of fundamental constitutional analysis. I just can't follow the analytical logic of your argument.
So, Your Honor, it's helpful to walk through an analysis an analogous statute, Montana, we prohibit minors from exercising entirely the fundamental right to privacy as applied to the intimate choice to marry if they are under 16. We then further condition the exercise of the right to privacy as applied to marriage for minors who are 16 and 17, premised on judicial and parental consent. That's the point of the preclusion clause in Article 2, Section 15, that the state doesn't need to satisfy strict scrutiny for those statutes. The state doesn't need to satisfy strict scrutiny when it says minors under 16 lack the ability to consent to sexual intercourse, their right to privacy under GRISCAN.
But that doesn't help you because with regard to young women who were 16 and 17, they have the legal statutory right. It's not illegal for them to consent to sexual intercourse. Now, is it?
No, Your Honor.
Okay, and nor do they have to obtain their parents' consent or blessing to engage in sexual intercourse when they're 16 and on. Isn't that correct?
Yes, Your Honor, but
So if they can do that, why would it be then that the product of that had no parental involvement whatsoever has to then be approved by the parent?
as this court recognized in the Megan Ray decision, for those minors 16, the older a minor is, I should say, the bypass determination is naturally going to start tilting in favor of that minor being able to demonstrate competency, which as a prerequisite allows them to obtain an abortion without parental involvement.
Counsel, a minor doesn't have to, 16, 17-year-old young woman does not have to demonstrate competency to engage in sexual intercourse.
Your Honor, by law, no, but we condition other elements of the right to privacy, such as marriage, that a minor cannot exercise the right to privacy to marry without judicial and parental consent.
We're not talking about marriage, we're talking about pregnancy and the consequences of pregnancy, and that necessarily involves at least some consideration or acknowledgement about how you get pregnant, does it not?
Your Honor, marriage and pregnancy are closely related. When we look to the pre-Dobbs line of federal case law, they all derive from the same right. And even Armstrong acknowledged that that line of cases, it's all the same right. It's the intimate personal choice aspect of the right to privacy. It comes from the same constitutional place. And that's the state's point, is that the state can validly condition how minors exercise, or in some cases preclude their ability to exercise a fundamental right if the law is specifically intended to protect them. And here, the consent is intended to protect.
That's a broad statement, but if you break it down into basic law school constitutional analysis, how do you get to that conclusion? You get to it because you're acknowledging that the state is showing, at least in the state's view of things, that the state has a compelling state interest, and it has a narrowly tailored measure that will then justify substantial infringement of the exercise of a fundamental right. Isn't that correct? That's just as a generic issue of constitutional analysis.
No, Your Honor, because the state doesn't believe strict scrutiny applies in this case. And to try and tack on a different way, if you look at plaintiff's argument, they're not arguing.
I'm looking at your argument. What you're saying to me is that Article 2, Section 10, the right to fundamental right to privacy, perhaps the strongest constitutional right to privacy in this country, doesn't apply if the state can get into the exception under Article 2, Section 15. Is that what you're saying?
Yes, Your Honor, to the extent the state's argument is if the state satisfies the prerequisite to Article 2, Section 15, that the law is intended to protect minors, then it becomes a rights balancing analysis, where you look to the nature of the state's infringement of the right versus the nature of the state's protected interest, and in this case, the fundamental rights of parents to care for their children.
So counsel, what,
If I could interrupt for just 1 minute, you keep saying laws which are intended to protect the rights of minors, but Article 2, Section 15 actually says laws which enhance the protection of such persons. So I think that's a completely different question than whether it's intended to.
To clarify, Your Honor, there does need to be an element of intent, and yes, some showing, I suppose, that the law accomplishes that protection.
But the law doesn't say which is intended to, it says which protects, which enhances the protection.
Your Honor, if you look to the statements of Delegate Monroe, who I believe put it best.
But the plain language is what we're interested in, and I don't need help understanding what that plain language says.
So, Your Honor, on 2 points on that. On the plain language, the district court clearly erred, because the district court said that the law is designed to escape strict scrutiny. The law needs to be designed to enhance the rights of minors. That's an incorrect read of the plain text of the Constitution. And this court does look to the intent of the delegates when it's construing constitutional provisions. And Delegate Monroe's statements that we cite in briefing are that the preclusion clause is an exception for cases in which a law is designed to protect minors. So we can, I suppose I'm using intent as shorthand for design, but the effect is the same, that the law needs to have a protective purpose to it.
so counsel, we need a specific or direction. I heard you say balancing constitutional rights. That sounds like balancing the right to privacy versus the right to know. That's not the test you're articulating, is it? I mean, what are you asking? We know what the state is asking in terms of a strict scrutiny review. So what test do we apply to include the enhanced protection analysis into the individual rights analysis of the under section 15?
Thank you, Your Honor. So as a first order matter, the law in question must enhance the protection of minors. And if the law enhances the protection of minors, and that's broader than just health and safety risks under Armstrong, if the law protects minors, then it goes to rights balancing, where you look to the full effect of the law in how it balances the rights of minors, the rights of parents in this case, and the nature of the state's interest. As this court has expressed in In re Megan Ray, that is satisfied so long as there is a bypass provision that ensures meaningful access to minors to obtain an abortion without having to go through a parental veto. And this law's judicial bypass accomplishes that tailoring effect.
So that's a new test that we apply. You're not asking us to apply rational basis or strict scrutiny or some other tier.
No, Your Honor, because I think that the language of Article 2, Section 15 envisions a different kind of test. That unlike Article 2, Section 10, where it says that the right to privacy can only be infringed by showing of a compelling interest, that language is absent from Article 2, Section 15.
But it's not absent from Article 2 rights.
Correct, Your Honor, but the preclusion clause in Article 2, Section 15 envisions balancing the rights of minors against the state's interest in protecting them. And I think this court expressed that in In re CH, where the infringement on the rights of minors must be balanced against the state's desire to provide them appropriate supervision and care.
All right, and you have not mentioned In re SLM. And it wasn't cited in your briefs, and that speaks, I guess, to me, that speaks to the test that we apply. The court actually applied a strict scrutiny test in the context of Section 15. and the enhanced protection. So can you address why, first, you haven't mentioned SLM, and I guess you think that it doesn't apply?
First, Your Honor, the state did address in re SLM in our opening brief when we distinguished the district court's application of the phrase enhance the rights of minors. That the state on in re SLM, the phrase enhance the rights of minors is not necessary to the outcome of that case. What the state did in that challenge was we imposed both a juvenile and adult sentence on a minor for a single crime. That law had other double jeopardy issues as expressed by the concurrence in that case. And it fails at that first step of Article 2, Section 15, that the state did not assert a protected interest in imposing a purely punitive sentence on minors for that crime.
But in re SLM, this court did hold that in the application, and we held that in that case it was equal protection in this case, but we held that under fundamental rights under Article 2 have to be read in conjunction with Article 2, Section 15, and did say, and I have some issues with in re SLM, ask counsel for Planned Parenthood, but we did unambiguously say that it was a strict scrutiny analysis.
Your Honor, respectfully, I think this court has to treat that as dicta, given the plain language of Article 2, Section 15, and the statements of the delegates that they intentionally included the preclusion clause of Article 2, Section 15 to allow for the infringement of minors. And this court should revert to the language in re CH.
No, and I get that, and I have issues with substituting rights for protections in re SLM. Like I said, that's a question for them. But as to the level of scrutiny, we unambiguously said that when it implicates under Article 2, Section 15 and minors' rights, fundamental rights under Article 2 broadly, that implicates a strict scrutiny analysis.
Your Honor, I don't believe that language from in re SLM can be correct for the reasons we cited in briefing with the host of Montana laws that long predate the 72 Constitution, that the states, it's not uncommon for the state to infringe on the rights of minors and the right to privacy specifically in a way that, to be honest, they haven't been challenged under strict scrutiny, but strict scrutiny is always difficult for the state to defend laws.
But counsel.
And we subject Article 2, Section 15.
Excuse me, counsel. I'm just astounded by what you just said. You refer to pre-1972 constitutional decisions and principles to bring them to bear in support of the state's position, when what we're talking about is how we deal with the effect of two post-1972 Montana constitutional provisions that were brand new in 1972, and how they relate to this case. How do you square that? I just astounded by that.
Your Honor, that's this court's decision in Nelson, that when you're interpreting a constitutional provision, you look to the context of the 72 convention, and that includes examining the statutory framework that existed at that time. Unless there,
Go ahead, you go ahead. I'm sorry.
Unless there is some evidence, which there's not in this case, that the delegates intended to upset the existing framework, then it has to be presumed that the delegates intended to leave it alone. And that's also
that's a backward argument when you're talking about revolutionary new constitutional rights that didn't exist before, that the Montana delegates to the 72 Constitution obviously intended change when they enshrined brand new rights, theretofore unrecognized under Montana law or the federal Constitution, into the Montana
I'd like to leave
Constitution.
Mr. Meade a couple of minutes for rebuttal, and unless the court has other questions, maybe we can save them till rebuttal and let him.
I want Excuse me, Justice Baker, I want this question answered.
Right.
Explain that to me.
So, Your Honor, your statement is directly contradictory to Delegate DeHood's statements about Article 2, Section 15, that he did not intend that section of Article 2 to be revolutionary in any way. That's a clear statement that Article 2, Section 15 was intended to preserve the existing structure of minor laws at that time. There are no further questions. I will reserve for rebuttal.
Ms. Hall.
Good morning, may it please the court. Tanis Holm on behalf of Appellees, Planned Parenthood of Montana and Samuel Dickman. At the outset, I want to address one of the concerns that Justice McKinnon had and posed to the state regarding what the balancing test would look like that the state proposes. And if the state really proposes that the right to privacy does not attach to minors, then what rights are you balancing if that right no longer exists? That is my question to the state. So we're here today.
Counsel, and I apologize, but before we, because as I indicated to Mr. Mead, and I want to pick up on this. And you do cite and rely on SLM in there for the broad language that it must enhance the rights of the minor under Article 2, Section 15, in addition to withstanding a strict scrutiny review. That is, and that is indeed what this court said in SLM. That's not what Article 2, Section 15 says. So, as Mr. Mead pointed out, it has to enhance the protections. And I think that there is something to be, discussed there and find out whether it's in balancing test or whether the law that enhances protections must demonstrate a compelling state interest or is subject to strict scrutiny because it impacts a fundamental right. But isn't SLM, just flat out, language-wise, is incorrect?
Well, I think LSM takes the spirit of what Article 2, Section 15 is intended to do. And it's a rights enhancing constitutional claim here. So,
well, the first part is to the extent that it says that all the fundamental rights enjoyed by adults are enjoyed by minors. But then it does say, and this is where I think that the language is incorrect in SLM, is it does say that, subject to laws that would enhance the protection of minors. And so, we said in Pengra that Article 2, Section 15 does not elevate the rights of minors above adults. What's the fundamental distinction between saying that it's going to enhance the rights versus enhance or elevate the rights? It doesn't make sense to me that, and I don't know if this is what the district court's intent was, but it doesn't make sense to me that you could say, okay, you enjoy the same rights, but then this other additional clause, the enhancement clause, somehow would give any minor rights that are greater than or enhanced than relative to adults.
well, can't you say that for the alternative as well? It can't act to take away all of those rights that constitutional provision confers onto minors. That cannot be the case, that a rights enhancing measure that was enacted as part of the Constitutional Convention for minors to confer all of the same rights onto minors can be taken away by just a mere showing of protection.
No, and I agree with that. You can't say, for example, you could certainly make the argument, and this is, somewhat of an issue I have with just the broader, that it doesn't abrogate those rights by just saying it protects minors. We can't, I would say that nobody would argue that, we're gonna say we're gonna microchip every child under the age of 18 and they can only get it removed. That would certainly enhance the protection of minors in terms of abductions and everything else if they go if they go missing, but it certainly would infringe on their right to privacy. And I think that, and maybe that, whether that falls within the balancing test, or do we apply strict scrutiny to the law that is designed to enhance the protection of minors? I mean, as Mr. Meade said, I mean, it's, that's kind of maybe the threshold question before you even get into the ballpark, it seems to me. And then you look at, and then maybe it's what, once you've determined that this is a law that enhances the protection of minors, you look at maybe what level of scrutiny to apply to them, what level of constitutional review.
I don't think there's a question here as to what level of scrutiny applies. It is strict scrutiny. It has to be under the rights enhancing provision. The separate provision that talks about the enhancements of protection and rights, or however language you want to use, it is an interplay. It is read in conjunction with the strict scrutiny standard. It cannot work to abrogate the strict scrutiny standard as the state suggests, not even looking at it. I think that provision works in tandem. And after you apply strict scrutiny, you look at the rights enhancement provision to see if the law enhances the rights and protections of the minors as a whole. And that's what all of the court.
But again, and I get this was that's what we said in SLM, but that is not, it's not enhances the rights, it enhances the protection. I mean, just from a plain language reading.
But the purpose of Article 2, Section 15 is a rights enhancement provision. That is the purpose of it. When you read the delegates' discussion on it, that is exactly what they intended to do. And it will be this court's decision on how it applies, but it certainly cannot work to abrogate the strict scrutiny standard. That would completely take away what the minors' rights provision intended to do. And that is our argument here in terms of this application of strict scrutiny. It has to apply here in this case.
Counsel, and I certainly want to hear from you on everything you have to say. But the test that we apply to the enhanced protection, how do we decide whether it enhances the protection of youth? Are you suggesting that's a strict scrutiny to that provision, or what? Do we look at the whole Section 15 together as a whole, or how do we evaluate whether the Consent Act actually or does not enhance protection of youth?
I think you need to look at it as a whole. Whether the Consent Act, whether it enhances minors' rights and protections as a whole. Now, courts analyze that in different ways. In SLM, they talked about it was an equal protection analysis, and they talked about enhancing the rights over adults in that situation. In Wickland, they also came at it a different way in terms of how they analyzed it under compelling state interest and narrow tailoring. So there are different ways to do that. Our suggestion is to look at it as a whole, whether the Consent Act works to enhance the protections and the rights to minors.
And applying the strict scrutiny to that.
Correct.
So you would essentially, I don't want to put, at least my notes reflect, I don't want to put words in your mouth, Mr. Meaden, you can correct me. But essentially then whether it enhances the protections of minors would essentially be the threshold question. And then we get into the constitutional analysis vis-a-vis the fundamental right that it's impacting.
And I disagree with that. I think that the standard that you apply is strict scrutiny right off the bat. You have to analyze first whether there's an implication of a fundamental right. Here there is, under the right to privacy or the protection of procreative autonomy, and then you apply strict scrutiny because that fundamental right is exactly what the Article 2, Section 15 rights enhancing provision talks about in terms of conferring those same rights that adults have onto minors. And so I think the
Would
first
you
step-
agree, would you agree that fundamental rights are those found in Article 2 and both Section 10 and Section 15 are found in Article 2? They're both fundamental rights.
Correct. Yes, yes,
And fundamental rights are reviewed on a strict scrutiny basis.
yes.
Okay.
And here, when we talk about the fundamental rights that minors have, the right to privacy, as this court has already determined in Weems and in Armstrong, the state has to come up with and have the burden of showing a medically acknowledged bona fide health risk clearly and convincingly. And that is the standard that applies here when you're looking at strict scrutiny in its application of the right to privacy standard. And the state seemingly doesn't dispute that that is the precedent. When you're talking about abortion rights, you have to look to Armstrong and Weems. And that standard also applies here when you're looking at minors' rights to privacy and their access to abortion. For minors, just like adult women, being forced by others to carry their pregnancy to term will have life-altering impact. It unquestionably infringes on their right to privacy. And despite this, the state argues that you should take away that ingrained right to privacy and apply this balancing test, which would be a novel approach. It has never been done by this court in terms of a fundamental right. And when you look at the Minors' Rights Clause, the Minors' Rights Clause ensures that the fundamental rights contained in the Declaration of Rights is conferred on minors. And I know the state relies heavily on the court case in Ray CH for their balancing test proposal, but SLM and Whitland did not apply that balancing test. And in Ray CH, that case also applied a strict scrutiny standard. So all of the precedent on this issue involves applying a strict scrutiny standard.
Counsel, after Weems, there's really no question, it's our court's precedent that abortions are safe. So that can't be part of the state's interest in protecting. I guess I want you to address some of the other points that they make in terms of why the Consent Act protects minors.
Yeah, so getting at the state's compelling state interests, none of them hit on what the application of a bona fide, medically acknowledged bona fide health risk. So in going through those, the state makes a number of stated interests. The only two that can be recognized as a bona fide health risk are protecting minors against physical and psychological harm and protecting minors against sexual abuse. Those are the only two compelling state interests that this court should even consider.
So
The
you
other ones
disagree-
aren't bona fide health risks.
I'm sorry, you disagree then with the district court's order that found four compelling interests, but concluded that the answer to those was not narrowly tailored in the bill. You disagree with that?
Well, I don't disagree that they weren't narrowly tailored. I agree with that. But the Weems decision came out after the district court's decision. So I know Armstrong was still in place, but you're right, the district court did not use the medically bona fide language in terms of applying it to the compelling stated interest. But that is the test by this court in determining whether there's a compelling state interest.
So then is it your position that when a minor is involved, there aren't any other compelling interests that could be identified because of the fact that the procedure will be performed on a minor?
Well, I think it's encompassed into medically bona fide health risk. So I think this court needs to look at that standard as to whether in applying it to minors. So when you look at the physical and psychological harm, this court has found in numerous cases that abortion is exceedingly safe. And so it's important to note that minors who seek abortion care, they're not left on an island by themselves to navigate the abortion process. They nearly always involve an adult in the process, whether that be a parent, a guardian, or another trusted adult. And then when they make their way to Planned Parenthood, there's a whole process of informed consent where the healthcare provider and the minor interact in a way that allows an evaluation and a discussion about the minor's questions, risks, and all the while screening for sexual abuse and other concerns. And this is important because the state takes issue with the fact that all minors should have a parent or guardian involved in this process. There are other individuals, trusted individuals that the minor has in the abortion process. And all of the major medical groups show that there's no evidence, there's no causal relationship between abortion and mental health problems. So this court has already found that abortion is exceedingly safe. Also, there are no mental health problems associated with abortion care in minors. So there's no compelling interest. And also, the state completely leaps over the fact that the Consent Act would aid in any stated interests. How would the Consent Act protect minors from physical and psychological harm? How would telling a parent, or actually giving a parent veto power over their child's decision to have an abortion, how would that protect a minor against psychological harm? They haven't pointed to any evidence in their briefing. The other interest that the state has stated is sexual violence and abuse and the prevention of such. And while protecting minors against sexual violence is a compelling interest, there isn't any evidence that the Consent Act would aid in that goal or would provide an enhancement over mandatory reporting laws. And that is key here because when we're looking at a narrowly tailored law, the law needs to be the least onerous to get at the means the state is trying to accomplish. We said that in Weems. Here, we have a mandatory reporting law that is narrowly tailored, that gets right at the heart of the issue of protecting minors who are sexually abused. And here, the state completely leaps over that and says, no, this law, this overreaching law that would apply to all minors under the age of 18, that's the answer. But we already know that's not the answer. We have a mandatory reporting law that speaks to that very issue. Not only that, we have the notice law, which is less onerous and less restrictive, also noting that it's more narrowly tailored.
So counsel, and I'm sorry, what did you, so the district court found, as far as the states, they identified 4 compelling interests for the act, and you said that there were only 2 of them that were compelling state interest.
Two that are compelling state interests that fall under the medically acknowledged bona fide health risk.
Okay, so the ensuring with, and where do you find, I mean, I'm looking at the 4 from the district court's order and what it held and what the state argued. And I'm just not sure I'm tracking. I thought I wrote down the correct ones. I'm not sure I'm tracking what of those 4 that were identified and that the district court found there was a compelling state interest, but that it was not the least restricted means of achieving that interest. Which 2 don't you think are advanced?
So the 2 I don't think that qualify as compelling state interests are protecting minors against their own immaturity. So in that situation, immaturity is not, first of all, a bona fide health risk. The interest in protecting minors from the immaturity, it requires context. And immaturity in and of itself is not a harm. And this caution is all the more necessary in Montana constitutional adjudication because, as I already explained,
But and I'm sorry, let me interrupt you just because I'm looking at the district court's order. I mean, what it was within the context of ensuring that the minor has fully informed decision making, and that the minor is fully informed, and what the district court held, if I'm recalling correctly, is that the Parental Notification Act served that purpose because it involved the parent, and that's basically what the state is saying, is that adults are going to be more well-equipped to remember. And my daughters don't remember when they had chicken pox or if they did. I mean, if you're talking about, and I'm not trying to be glib there, but if you're talking about medical histories, there's a lot of medical history that parents know about their children. The children may not recall themselves. And so isn't that within the context of, I mean, you know, if it's a teenager that's a child who's going to, you know, has an allergy to acetaminophen, may not know that, they just know that there's no Tylenol in the house. I mean, isn't that something that is advanced? Isn't there a compelling state interest in ensuring that an adult, and I'm not talking about necessarily consent, because within this context, where the district court found that the Notification Act served this purpose, but isn't there a compelling state interest in ensuring that when in any medical procedure that there's an accurate history?
But there's no evidence on the record that minors do a poor job at communicating that to their healthcare providers. There's a bunch of evidence in the record that shows, in literature, that shows minors seeking abortion care, like other medical care, are behaving responsibly and thoughtfully, including all of those things that you just mentioned. I mean, take, for example, all of the other medical procedures that minors can go through without consent of their parents. Minors can go, they can get birth control. Minors can proceed to having through their pregnancy. Minors can have a C-section. Minors can get treatment for STD, all without telling their parents or receiving consent from their parents. If they can do that there, why can't they do that with abortion? So the same application applies there. There's no evidence then that minors are poor historians at telling their providers what's going on with them and giving an accurate medical history in that context, in the context of abortion care and their health care. So no, we don't agree that it's a compelling state interest because there's no connection there. And if the state truly had an interest in protecting minors in that way, then why don't those parental consent laws apply in all other instances of procreative autonomy? And that's not the case. There's also an argument from the state that they have an interest in protecting the constitutional rights of parents to rear children who are members of their household. And our position is that the rights of parents do not outweigh the constitutional rights of those minors. The parental right to rear one's child is a right to be free from state interference, and not the positive right to enlist the state's coercive powers as an aid for parental control. And while the state may not interfere with the parent's upbringing of a child, it does not translate that the parents have a right to prevent or even be informed about a child's exercise of her own constitutionally protected rights. And then whatever interest the state has in promoting parental authority must be exercised neutrally, not as to favor childbirth over abortion, and certainly not to step in the shoes of parents to regulate the family relationship. And that is what the state is doing here. It is stepping in the shoes of parents, trying to regulate the relationship with the family, singling out abortion as opposed to all other healthcare services.
Counsel, I think that's a very important consideration in this case is the rights of parents. And you've cited a couple of cases, I believe, that have addressed that analysis that you just set forth. Is it this widespread that analysis applies, the courts have applied that analysis, or can you give me some authority for that?
Sure. So in the case in Ray, the state of CKO, the court outlined what the parental liberty interest means. And this court held that while parents have a fundamental right to parent their children, that right is not absolute, especially when there is a conflict of interest or you have competing interests between a minor and a parent. And this court has routinely held that a parent's right to parent is not outweighed by, say, a child's need for safe and stable home. And certainly can't, abrogate a child's own right to a fundamental right under the Constitution. So the court really needs to look at the interests of the parent and the child in assessing that. And here, the interests aren't aligned necessarily, and that is why the court cannot impose a parental's authority to abrogate the fundamental constitutional rights of minors. And then the state argues that the judicial bypass procedure corrects all of the problems with the Consent Act. And they fervently defend their position by stating that it cures the defects and it offers an escape hatch for the minors. The judicial bypass process doesn't aid in any of the state's compelling interests. So it doesn't work to correct all of the defects with their stated compelling interests. When looking at strict scrutiny and seeing whether the compelling state interests are in fact compelling, whether they're bona fide, medically acknowledged bona fide health risks, they still fail. And enacting the judicial bypass procedure doesn't fix that, nor does it fix the issues with narrow tailoring. And that's aside the point from all of the roadblocks involved in receiving a judicial bypass. The bypass process gives no framework or guidance on how a minor can engage in the process, and many minors are and will be unable to access the process to even begin with. The bypass language in and of itself is not accurate on how petitions are to be filed and how the guardian ad litem appointment process and counsel appointment process takes place. There's no guidance as to where the petitions are to be filed, and that presupposes that a minor can navigate the court process without an attorney and file a petition on her own. There are no forms that have been created in the district court clerk's office or any forms available online. And the two bypasses that are part of this court's record resulted in full-blown evidentiary hearings. And while Planned Parenthood of Montana aided in connecting the minors to those attorneys, Planned Parenthood doesn't treat all minors in Montana. And certainly that presupposes that the minor is going to get to Planned Parenthood to begin with. The state suggests that the minor doesn't have to go to court through this process. That has not been the case in Montana, and that has not been the case according to the record. Both of the bypasses on record in this case involved evidentiary hearings where minors were questioned under oath by an attorney, questioned by the judge in matters that are incredibly personal, incredibly important. There's a deluge of evidence on the record about how this process is extremely harmful to minors. Not only do minors have to meet with an attorney to adequately prepare for the hearing, but they have to attend the hearing, all without drawing suspicion from their parents or guardian, because the minor is also in school, often without transportation. It's difficult, stressful, and time-consuming for anybody, let alone minors. As this court stated in Whitland, it increases stress, delay, and potential medical complications. Even if a minor navigates that entire process and makes it through the hearing and receives an order, there's delay. In Montana, there's a real problem with access to abortion. And while abortion is a safe procedure, it's undisputed that the risk of the procedure rises with each additional week the pregnancy advances. Medication abortion is only available 10 weeks after the first day of the woman's last menstruation period. And medication abortions are available in Helena, Billings, Missoula, and Great Falls. But after that, Helena is the only place they can receive an abortion. That causes extreme delay in situations where these judicial bypasses take place. In the record for these two judicial bypasses, I think there was a delay of 10 days and 2 weeks. When we look at narrow tailoring, there's no causal relationship between the state's stated interest and the enforcement of the Consent Act. And a narrowly tailored law is the least onerous law that can only be taken to achieve the state's objective. It's not narrowly tailored because it does not permit healthcare providers to help determine whether the minor is capable of consent or whether it is in her best interest to seek consent of a parent. It's not narrowly tailored because it applies regardless of the minor's maturity. It's not narrowly tailored because it doesn't allow anyone else aside from a parent or guardian to provide the requisite consent. It erects additional burdensome identification requirements that go far beyond what is necessary. And the bypass process doesn't cure these defects, and it harms minors for several reasons. They're less likely to proceed with confidential medical care, which is very important. It harms family relationships because forced disclosure in dysfunctional families exacerbates instability. It will cause delay, and it will cause some minors to force to carry their pregnancy to term and face health and psychological risks associated with that. And taking it one step further regarding the enhancement provision, it does not enhance the rights or protections of minors under Article 2, Section 15. The state has not met its clear and convincing burden standard that its stated interests are compelling or that they present a medically acknowledged bona fide health risk. For these reasons, we ask that the Supreme Court affirm the district court's decision. Thank you.
Thank you, Ms. Hull. Rebuttal, and we'll give Mr. Mead 5 minutes. You had a lot of questions from the court, and there may still be questions. So we'll give you a little extra, and I'd like to begin because I sort of cut you off, Justice Sandberg, by asking if your question was answered.
Thank you, Justice Baker. No, you didn't cut me off. I asked my question, and I believe Mr. Mead answered it. So we can proceed, and there's no problem there, but thank you for checking.
All right, you may proceed.
Thank you, Your Honors. Three main points. First, on the appropriate standard of review, applying strict scrutiny to all cases under Article 2, Section 15 removes the practical effect of the preclusion clause. That regardless of the nature of the state's protected interest, that claim must still be treated under strict scrutiny, then there's simply no difference, and that preclusion clause loses its meaning. And that's not what was envisioned when Delegate Monroe told the convention that the preclusion clause is intended to preserve those laws that infringe on a minor's rights when it is for their protective interest.
Presumably so, but in Ray CH, the court applied strict scrutiny and still found a compelling state interest to justify the legislation.
And so touching on that, Your Honor, what plaintiffs just said that, well, the only valid interests under this are bona fide medical risk. Again, that merges the test for adults' rights versus minor rights. In rights balancing is the appropriate standard here, because when we're talking about the protected interest, it can go beyond what is allowed under Armstrong. It can be something like getting to the heart of Article 2, Section 15, that we recognize minors lack that level of maturity for fully informed decision making. And so allowing parental involvement furthers that interest. It might not be speaking directly to a bona fide medical risk, but it is speaking that we want to get them more protection by getting them a broader support network.
But counsel, you continually speak broadly about parental involvement, and I get that, but again, that goes back to if there is strict scrutiny as we applied in CH and SLM, then I mean, isn't the least restricted means of that parental notification as opposed to consent? And I want to and I'll allow you to answer both, because in that respect, the legislature stated in 5020-502 the purposes and findings for the Parental Consent Act. It enumerated this is what the legislature has found, and it then enumerated what the purpose of the act is, and it lists four items. In 95, when it enacted the Parental Notification Act, which was subsequently repealed, but when the 95 Act, that Those findings and those purposes are identical. 50-20-202 is identical. And so I'm kind of wrestling with, if we're looking at what is the least restrictive, the legislature stated that the Notification Act served all these purposes, went in 50-20-202. So what was the necessity for 50-20-502 for the consent?
Understood, Your Honor, and I'll just point you back to what I said earlier, that what the Consent Act is trying to close is that same gap that's identified by Planned Parenthood in the Notice Act, that notice can be given to someone other than the adult. That's what happened in the Roe case in Ohio. The Consent Act's identification requirements are designed to close that gap. And that's the best I can concisely answer your question, Your Honor.
Mr. Mead, I think at least a large part of your argument, and I don't mean to speak for you, but it focuses on this idea that this act enhances protection for minors. And it seems to me, and I wonder if you agree, that one man's enhancement of rights is another woman's enhancement or increase of risk.
So, First, Your Honor, the state's not arguing that the Consent Act enhances the rights of minors. It's,
Well, I think I said enhancement of protection. I think that was the word I used, or the phrase.
I might have misheard. What the act is doing, if you look to the Supreme Court's statement in Matheson, there is a natural benefit that occurs with parental involvement in a minor's choice to get an abortion. That's because parents have access to additional medical history for the minor. The parents are there to provide that follow-on care. And that is the natural protective aspect that occurs under the Consent Act, that when the parent is involved.
Okay, thank you. I don't think you answered my question, but I think I understand your position.
If there are no further questions.
Thank you. This concludes the argument. I want to thank all counsel for your presentations, and the court will take this matter under advisement and issue a decision. Court is adjourned.